Hello and welcome to this special edition of Court Corner, where we highlight the impact of COVID-induced lockdowns and a halt in physical hearings on lawyers and the subsequent loss of income and livelihoods. In a study conducted by the Vidhi Centre for Legal Policy Study last year, it found that 79% of the lawyers surveyed at 8 high courts are earning less than 10,000 rupees a month with up to 2 years of legal practice. The Chief Justice, N.V. Ramana, has written to the IT Ministry expressing concerns about poor connectivity in rural and hilly areas, which has adversely affected the delivery of justice. Justice Ramana also added that the digital divide has pushed a whole generation of lawyers out of the system and has deprived thousands of young lawyers their livelihood. The Chief Justice has asked the Centre to recognise all court functionaries as frontline workers for purposes of government relief. In fact, in July last year, the Bar Council of Delhi had written to the Prime Minister requesting an allocation of 500 crore rupees from the contingency fund as well as from the Prime Minister Cares Fund to mitigate their hardship. Let's go across to my colleague Ashmit Kumar, who's been following up the developments on this front. Ashmit, there is no clarity on when physical hearings are expected to begin, but even if they were to begin, it seems fairly clear that we will be headed into some sort of a hybrid mode of work, at least in the foreseeable future. Now, what is the status of the requests made by bar associations about the possible loss of livelihood and the impact on lawyers?
Well, a couple of aspects here. Let's keep in mind that as of today, it's been over 15 months that we have seen virtual or hybrid hearings across various high courts, including the Supreme Court as well, which has resulted, and this we're getting from hearing from the bar associations themselves, has led to a large amount of loss of livelihoods for a lot of young lawyers, young advocates, court clerks, court staff. All of them have suffered, and that is the version that we're getting. Now, what we understand is that repeatedly there have been requests coming in from the bar association. In fact, prior to the second wave, we very nearly had various high courts resuming physical hearing. However, we were met with the second wave. There were very grave health concerns, and on the back of that, having established this system of virtual hearing, the high courts as well as the top court, the Supreme Court, continued to proceed along this trajectory of having virtual hearing. But now that we are past the peak of the second wave, those questions are beginning to emerge once again. We understand that the Supreme Court Bar Association has already written to the Chief Justice of India, in fact pointing out that there should be a resumption of physical hearing subject to vaccination of the lawyers in question. In fact, we also have the Chief Justice, as you pointed out, he has also in fact echoed similar sentiments that there is seems to be a digital divide. There has been a loss of livelihood, and that there needs to be some form of mechanism that needs to be worked out to allow relief to the parties who have been aggrieved, such as the lawyers, advocates, young advocates. But what is important here and what is striking here is that at various points in time, there were challenges across various high courts. There were petitions rather before various high courts which had sought for some relief coming for lawyers. The Centre's position, however, has been unrelenting. Centre has made it clear that the relief that has come by way of their various schemes, and mind you, there is no specific scheme aimed at lawyers, the Centre remained firm on its position that they cannot customize reliefs as per individual groups, and that they will have a more macro approach to this entire exercise. So the Centre has been unrelenting. We're yet to hear from the government in terms of any funds that they would allocate for granting relief. But clearly, there is a request coming in from the Bar Association, and an appeal coming from the Bar Association that if nothing else, let's have physical hearings resume. But of course, let's keep in mind that Justice Chandrachud, who heads the E-Committee, has given a very distinct push towards digitization of judicial processes. So it's up to the courts now. We'll of course be finding out soon.
Yes, we will hopefully get more clarity on this. But joining us now to take this discussion forward is Vikas Singh, the President of the Supreme Court Bar Association, Mohit Mathur, the President of the Delhi High Court Bar Association. Also with us, Aragya Sen Gupta, Research Director at the Vidhi Centre for Legal Policy. Ashmit, of course, here with us as well. Gentlemen, appreciate you joining us here on the program. Mr. Singh, if I could start by asking you, if you could tell us what has the impact been? I mean, there are about 16 lakh lawyers enrolled with various bar associations across the country. How severely have lawyers been impacted? Is there any data that you can share with us?
Well, to be honest, the numbers that come to my mind are that workload has come down to more than 50% less than the normal workload. And in fact, it was about 20% of the normal workload in the initial part of the digital, called digital hearing that started. And out of the whatever workload that has come down, the lawyers who are with work and who are not with work is also in the range of 20 to 80. So 20% are having some work and, of course, reduced work, not the same work as earlier. And 80% are virtually without work. So there is a huge demand for firstly, restoration of physical hearing, and also for some kind of a financial package for lawyers. We on our own have collected money and tried to distribute amongst our lawyers who we felt could be given some relief at least from our side. But this can only be set right only if the physical hearing starts, because in the physical hearing process there are several aspects of legal dispensation where lawyers play lots of roles, like applications, mentioning, and so in a day, if there was, say, supposing 100 bills to be raised, so to say, because ultimately it involves to how does a lawyer earn money? He raises money by making bills. So if you were to make 100 bills in a day, I would say that the billing has come down to about 25, 30 in a day as compared to 100. So that's the kind of loss to lawyers, and that too because of the digital divide. That work has also gone to a very select few. And most of the lawyers, because when you thrust something on a particular institution without a pre-thought on it, this kind of thing is bound to happen. And according to me, physical hearing is the need of the hour. Physical hearing is what the Constitution prescribes, and there is no occasion for the physical hearing to be given a go-by. However much we may be able to do digitization, or we may be able to improve the technical infrastructure, physical hearing is there, will remain, and is bound to stay. And that's the only way we can restore the lost work that the lawyers have had in the last 1.5 years.
So several reasons that you brought up there, Mr. Singh, in terms of why we are seeing this impact across the board on lawyers. One, of course, the main one is the pace of work having come down significantly. Only urgent matters are being taken up for the virtual hearings. But Mr. Mathur, let me ask you, in the context of what we heard there from Ashmit, and several pleas have been made seeking financial relief, financial aid for the lawyer community in specific, but that has not come to pass. So in the interim, what could the solution be, as it is very clear that, while we may not be headed into a third wave as of today, but that possibility is alive. We're still tracking about 50,000 cases in India on a daily basis. So in a hybrid environment, what could the via media be? What could the interim solutions be for this community?
Thanks, Shireen. In fact, I would echo what Vikas Bhai has just said. And there has been a tremendous loss of work, because once you start restricting the matters which are to be listed, then it affects the entire system, and it affects the lawyers in general. And he is also right, and I voice that opinion, that it's only because of the digital, then the technology which is now being used. When you are trusting this kind of a technology in a absolutely sudden move, not everybody is equipped to take care of this technology, to use this technology to his best benefit. And now when the woes of the lawyers are increasing, what is actually required in the interregnum, we as a community, as associations, we are trying to somehow gather funds from amongst our own members, our senior members who are a little more prosperous and who are able to afford things. We are contributing to somehow let and help our junior, younger lawyers and those who have been hugely impacted. But unless and until the impetus and the stimulus comes from the government and the resources, because the resources are limited as far as the lawyers themselves are concerned, how much would we be able to help? Like Supreme Court has collected funds. Our own association, High Court Bar Association, also we have started collecting funds. And the lawyers, the seniors and the law firms, many of them have contributed. And we are distributing that amongst the lawyers for those who have been impacted either on the health front or those who have otherwise been financially impacted because they have not been able to earn properly during this period. We did so in 2020 also in the first wave. We didn't anticipate that there would be a situation which we'll have to do it again. So we are doing it again. But any kind of a stimulus collected by individuals has to have its own restrictions as far as the resources are concerned. unless and until the government comes
Correct.
out with some kind of a stimulus where some kind of a, if nothing else, at least a fund is made available to the lawyer to utilize it for some time, at least to tide over these woes and tide over this crisis till the time the normalcy is restored. In given situations, one could even think of a sort of a loan sort of a thing, but with a moratorium period, allowing people to come back to their normal work and then repay it back. Or otherwise, any other kind of a solution would also be some kind of a financial help, because today the lawyers are not just suffering financially, they have also been impacted physically, because Corona has not spared any community or any family as such. And there is a huge impact, loss of work, where people are not able to foresee what is going to happen. That emotionally is disturbing. So the stimulus has to come from the government.
No, it is disturbing. I understand that the point that you make, Mr. Mathur, and it is the case across different sectors. Many sectors have been hit harder than others. You're talking about the legal community and the legal profession, but many sectors have been hit on account of the COVID-19 pandemic, and everyone is seeking some sort of relief. You're saying lawyers require relief. It cannot be left only to the bar associations to deliver financial aid and financial support, which is really a voluntary exercise, and that's how relief is being provided, at least at this point in time. Aragya, let me put this across to you, and since we're addressing what the road ahead should look like in terms of interim solutions, now, there are suggestions that at least in the interim, could there be ways for lawyers to be able to do something else part-time, take up an interim job, for instance, but that's not allowed currently under the Advocates Act, because to Mr. Mathur and Mr. Singh's point, I mean, if there is no financial relief in the offing, then what happens to those who are without work?
Thanks very much, Shireen. I think just one point before I come to this interim solution. I think it's important to understand why this is happening. This is not happening only because of the fact that we've moved from physical to virtual. It's happening because in this virtual medium, we are only taking certain kinds of cases, right? So all cases are not being listed. So I think it's important to note that this changeover and this reduction in lawyer salaries is not happening because we've changed over from physical to digital, but because our digital means are ill-equipped to handle 100% of cases that we have in the system. So I think the way forward at this point of time, as I'm just looking at my 10-year-old cousin doing his school on his WhatsApp, on his phone, and his iPad, and my 85-year-old grandmother being on her computer all the time, it seems like lawyers have to adjust. And I think we have to be clear that the future of the courts is in some hybrid form, which includes physical hearings, of course, but also includes digital hearings on a range of matters. So I think if 80-year-old grandmothers and 10-year-old kids can adjust, lawyers can adjust too, and we don't want to be seen as a community that is a community of Luddites that don't want to adjust. Number one. Number two, in terms of interim solutions, I think Mr. Singh's suggestion is right, that we need to start some form of physical courts across the country, because COVID is here to stay. It's not going to go away. We have to look at which kinds of matters we can get back in court. That's the first thing. Second thing, in terms of other solutions, I don't think, Shireen, while it may seem attractive that, can you do something else? But a lawyer has been trained as a lawyer, has been working as a lawyer for a number of years. And so it's not something that they can switch over and start doing something else. I don't think that's a solution. And the third thing, and I think this is why perhaps fiscal packages have not been coming from the government, I think there is a general sense in society that lawyers are prosperous, right? And especially, Shireen, in your shows, you have lawyers who are sitting in their farmhouses and in London and Goa. So there's a general impression in society that that's the case. But actually, that's not the case. As we looked at as you had mentioned, our study, as in the lawyers in 2 years who have done 2 years of practice have salaries, and we did it in 4 high courts, and this is not even district courts. They have salaries as low as 5,000 to 8,000 rupees. So the fact is that this is not a prosperous profession in the mean. So we have to take into account that lawyers, like every other society, has been hard hit, but has to adjust to the changing times, and the changing times are digital.
And thank you very much, Aragya, for so comprehensively, placing what the problem is and why we are actually seeing this disproportionate impact as far as lawyers are concerned as we've gone digital. And as Aragya, Mr. Mohit Mathur and Vikas Singh were pointing out, it's not just the fact that lawyers have had to go digital or the courts have gone digital. It is because the quantum of work has shrunk and has shrunk very significantly. That is proving to be one of the biggest challenges, because only urgent matters are being taken up, and hence the plea there to restart physical hearings, or to Aragya's point, to at least get more matters onto the digital hearings versus what we are currently seeing today. My colleague Ashmit, of course, tracks the courts as well very closely. Ashmit, go ahead.
Well, one of the questions that I want to bring into play here, if I can come across to you, Mr. Vikas Singh, is that when you made their application, we understand that the SCBA has made a fresh application towards a resumption of physical hearing. We have understood the need for that. The question I want to ask you is that how do we go about it, keeping in mind that there could perhaps be a third wave in the offing? And this I'm asking in context of some of the examples that we've seen. We've seen the likes of Rajasthan High Court, J&K High Court allow resumption of physical hearing subject to vaccination certificates. Is that something we can look at, that maybe lawyers who have had one jab, maybe they can be considered deemed safe to have a physical hearing in courtrooms? Is that something that's workable?
Well, the point that I've made is that when you talk of a third wave, you basically talk of people, behaving irresponsibly. And when you talk of behaving irresponsibly, you talk of uncontrolled environments. So, for instance, marketplaces or, holiday makers, or we had the Kumbh Melas. So these are uncontrolled environments where you can't have any control over who's coming and what is his history and what kind of behavior he has to follow. If you have COVID-appropriate behavior, and if you can, and courtrooms are definitely controlled environments where you can have firstly COVID-appropriate behavior, which means that masking is mandatory. Sanitization is mandatory. Hand sanitization is also mandatory. And we have also done vaccination. So when I say vaccination, in the Supreme Court, we bought vaccines at the private rates early in May for the 18 to 45 category. And for the above 45 category, I started vaccinating on the 16th of March itself. Justice Ramanna, in fact, came and he inaugurated the vaccination camp in Supreme Court. So most of the Supreme Court, the stakeholders, the media persons, the clerks, the family members, the domestic staff, we vaccinated everybody in the Supreme Court. So the idea is that if we have majorly people vaccinated, we don't allow visitors to come in for some time, so that till the third wave threat is over. Visitors can, of course, see the hearing virtually, and the media persons also can see virtually because they don't have to actually, participate in the hearing in that sense. So if we have the stakeholders coming down and the number of matters that are being listed in court also to be, sort of regulated hourly, so that if you have a matter in the second hour, you need to come in the first hour at all. All this can be done, and that is all part of my suggestion, where physical hearing, because nobody really knows whether there'll be a third wave and what will come. So we have to start with the COVID approach behavior and move on. We just can't wait for a third wave and in that process not do anything. So that's a very important point as far as the Supreme Court.
Yes, arrive at workable, practical guidelines that can be used and put in place to ensure that some sort of physical hearing kickstarts, restarts. But Aragya, I want to come back and address the issue of the digital divide that you spoke of. And you said that, the courts are ill-equipped digitally to deal with a larger quantum or a larger volume of work. And I go back to what Justice Ramanna has also cautioned about, saying that, there is this digital divide and a whole generation of lawyers is being pushed out of the system on account of it. Now, what are the key challenges there, and what do you believe the roadmap needs to be? What needs to be prioritized, even as we move towards a hybrid or a much more hybrid world, the constraints on the digital side that need course correction?
Yeah, so Shireen, the first point is that I think we need to realize that the judicial system, even in its physical form, was a creaking administrative system. There were lots of benefits to it, but take a simple, it was a slow system. We know that delays are endemic in the judicial system. So it takes, and just to give you a very simple example, it takes 273 days on average to deliver summons in courts in Bangalore. Okay, now this is a huge number. This is like almost a year to deliver a letter to tell someone to come to court. This is physical hearing. So I think digital, one, provides an opportunity to try and take a quantum leap in some of these areas where courts are slow. Coming to your question as to how we can do this, and I think there are three concrete suggestions that I have. First, Justice Chandrachud's committee has already put in place e-filing norms in the Supreme Court as well as in other high courts. We are in phase 0 of this e-filing system, and we have this very awkward system where you have to file your cases digitally, but also then you have to provide a hard copy in several courts. I think number one, we have to bolster our e-filing system so that we can, over a course of the next 2 to 3 years, ensure that courts go paperless. And I think that's one. And Justice Chandrachud's e-committee, as Ashwath was saying, has already made some moves in that direction. Number one. Number two, the point that the Chief Justice of India rightly makes in terms of infrastructure. And we found, as in a survey, that most courts in the country, given the fact that most of them at worst are in district towns, most of them have some form of connectivity. They are on the grid. We are not dealing with a situation where there are courts in places of the grid, except there are 44 courts in the country, according to our estimation, which don't have digital connectivity. It's absolutely critical that we hook up every single court in the country, with Jio promising that every Indian in every village will have it. I don't think it's very hard administratively for this to happen. That's the second thing that needs to be done. And number three, in terms of the actual softwares that are used in order to conduct court hearings, and I think this is a massive pain point, and Mr. Singh and Mr. Mathur are here who do this on an everyday basis. The fact is that we need to have video conferencing solutions that are customized for courts, rather than courts customizing to video conferencing solutions. So you have various courts in the country using Zoom, WebEx, video, different softwares, in different formats. We need to have a dedicated solution for judicial hearings. And this is a third solution that I think needs to be done. And overall, and I'll just end here with this, Shireen, because I know you're stuck for time. The point is that I think digital provides an opportunity. Any digital system takes a while to settle in. As I said, we are in phase 0. So this is not the time to ditch digital. This is the time to adopt digital in a hybrid fashion so that we can make the transition in 3 to 5 years' time.
Right, Aragya. That's an interesting point that you make about customizing digital solutions. And one problem that I believe lawyers face all the time is that whenever there's a matter of public interest, we find that the virtual room that has been arranged for the number of participants exceeds the capacity of the room, which often leads to delays, which leads to, in fact, miscommunication, senior advocates not being able to log in. So, yes, there is a urgent need for, in fact, customizing digital solutions. But speaking of the digital divide, Mr. Mathur, if I may come to you, while there is a significant distinction push coming from the bar that yes, there needs to be resumption of physical hearing, there are also those who are in fact very comfortable in this new digital virtual environment, who are aggressively pushing for the virtual hearings to continue. So there seems to be a clear divide within the bar going forward. How do we resolve this disconnect between members of the bar? Because going forward, if we have a mandatory hearing, what happens to those who are more than comfortable in this virtual format and in fact are more comfortable than the physical hearing format? How do we bridge this gap and resolve this issue within the bar?
See, my comfort in a particular procedure or a particular mode of hearing cannot be the governing factor in any manner whatsoever. So tomorrow, if I start saying that all matters should be done only from one particular place because I am comfortable in it, cannot be the answer. This digital technology was employed for the pandemic because the access to justice could not be denied to people who sought it and who needed it. Now, if today, because without moving myself and only from shifting screens, I can move from Jammu Kashmir to Kanyakumari and different courts and attend the hearings, that is only a very minuscule percentage which wants that. I don't believe in harping on this fact that only digital should be allowed or only physical should be allowed. I believe certain jurisdictions, the digital mode can perhaps be employed to the advantage because the restriction of time or attendance and joining where you want to or when you want to, probably in those jurisdictions it may be permissible, but not in the ordinary course. And as Mr. Singh also pointed out, The rule is physical hearing. Today, if for any reason whatsoever, we are not able to carry on with physical hearing, perhaps in certain jurisdictions, you can continue at a later point of time. But what we are encountering, and I am sure you would also have found out by now, that as far as our own High Court is concerned, Delhi High Court, I can say, digitization of the record itself is not there. So how do I raise my petition or how do I argue my petition today if it is not even digitized and the judge is not having it on a digital way? The filing till 2020 was being done in most of the jurisdictions in the High Court only in a physical format. During the pandemic last year, it took them 1 year to digitize records from 16th of March 2020 backwards, and they've reached up to 1/1/2018. So if in 1 year's time they were able to only digitize record for 3 years, now you expect the High Courts or the Supreme Court, with the constitutional courts are court of records. So the records must be maintained. So if it has to be done in a digital record and we have pendency from 2015 or 2010, how do you reach those years in those cases unless and until either we wait for eternity for all these records to be digitized? Now, if any members of the bar who are the advocates for digital technology, I am not saying that digital technology should not be adopted. Neither has High Court Bar at any point of time said it. As far as the High Court Bar is concerned, we have always been saying that please adopt a procedure, whether you go by digital or by the physical hearing, you must allow all matters to be listed, all matters to be heard. Now, you can't deny somebody merely because I had cases filed in 2016 or 17 and I have not got a case of the High Court in 2018, 19 or 20, I should be deprived of my hearings in the High Court. What I will have to adopt is, by filing a miscellaneous application, I will have to get that matter listed somehow. But then the difficulty which comes is that the judge would not have the record with him of the main case. And this is exactly, see, the digital divide is not merely the availability of the technology, but the fact that the entire documents, etc., the matter which is to be argued should be on the digital platform available to everyone. So merely advocating a particular mode.
I think each one of you has made important suggestions, and as is being pointed out here by Vikas Singh, Mohit Mathur, and Aragya Sen Gupta, it's not as if the courts are not keen to adopt digital technology or go digital. There are constraints at this point in time, and there needs to be a very clear transition roadmap with the priorities that they have spelt out for us in focus. But the hope at this point in time is that at least in terms of just being able to take up more matters, that should certainly be the order of the day, because ordinary people, not just lawyers, ordinary people are also running from pillar to post in order to try and get justice. Vikas Singh, Mohit Mathur, Aragya Sen Gupta, appreciate you joining us here on Court Corner. We will, of course, continue this conversation as things develop, but for this evening, appreciate your time. We'll take a break. A lot more coming up. Don't go anywhere. We're back in a moment.